Well, hello everyone, and welcome to One Civil Law, where as always we learn through the misfortunes of others. And welcome, finally, to the start of the trial stream. That is going to be Sarah Boone. I'm excited, and I hope you are too, because it is truly an exciting thing to see, and it's going to be glorious. So we'll see how it all goes. Should be great. So Sarah Boone, as I'm sure you all know, is on charge for second-degree murder for the murder of her boyfriend, and she has refused a plea deal that would have led her plead guilty to manslaughter and would have effectively allowed her to be out in about 6 years, give or take. She would have almost certainly gone, 15 years. That was what the offer was, 15 years. So she served 4, and she would have gotten good credit time. So she would have been out in, say, 5 more years, give or take, something like that, depending on how you're counting these things. So she has turned that down in somewhat a perplexing move, to be honest, because the state's theory of the case makes a lot more sense. Plus, there's still a pretty half decent chance that she's not going to be allowed to make the self defense argument because she can't make the predicate. And the state has basically alerted the defense to this and basically said in so many words that, when we get there, we're going to basically say that she can't offer the defense because it doesn't make any sense. They need an overt act by the deceased, which they don't have. She doesn't have it. She doesn't have the overt act. So here's the state's theory of the case. And there doesn't seem to be a difference on the theory of the case, just the motivation. So here's the theory of the case. Sarah Boone and her boyfriend were having a fun day, a Sunday fun day, and doing activities, arts and crafts, and hanging out and playing games. And apparently, one of the games they decided to play was hide and seek, even though she knew exactly where he was. This doesn't really make sense, but we're going to play hide and seek anyway. So he gets into this suitcase with her help to play hide and seek, which again doesn't really make sense. And then, he wanted to leave the suitcase, and she was not having it. She threw the suitcase around. She used a baseball bat to swat at his fingers and hit the suitcase to prevent him from leaving. And as he begged for his life, she went, shh. And that's pretty much the end of the game when it comes to murder. So basically, depraved heart murder with depraved indifference, with callousness, with intentionality of not caring. She chose to not care as he was begging for her life and took steps actively to prevent him from not getting his fate. So that's depraved heart murder with the knowing of what would occur, with knowing that he was going to die because he was begging for his life and saying he couldn't breathe. So with knowledge that he was going to die, she had callous, wanton indifference, depraved heart murder, and so murder too. I'm like, sounds about right to me. Now, her theory of the case so far seems to be battered spouse, which doesn't really make sense in this fact scenario. Not for least of reasons that she does not have an overt act from him that would be the impetus for her to act in self-defense. There's no overt act. The closest that we've got, apparently, is him sticking his hands out of the suitcase, which, of course, he has the right to do because he'd like very much to not, suffocate. So he'd like very much to try to not be in the suitcase anymore. But apparently, that's the overt act because if he gets out of the suitcase, he's going to be a really dangerous threat to her. And he might, when he gets out of the suitcase, he might beat her and stuff. And it's like, that doesn't really make sense. How can the overt act be something he's fully legally allowed to do? He's obviously allowed to escape the suitcase. There's nothing preventing him legally from escaping the suitcase. So, how can him trying to escape the suitcase be the overt act that puts her at threat? It doesn't really make sense. And the state has pointed this out already and basically said, when we get there, when she says this on the stand, we're going to object and say there's no overt act. And therefore, this defense can't work. So we've sort of already teed up the idea that this defense may not be able to be offered to the jury. The jury may never hear this defense at all. The idea of self-defense, they may never hear it because this is an affirmative defense, which means the defense has to make the initial burden of production. They have to put forward any evidence at all that supports the defense. And one of the elements they need to show is the overt act by the decedent that provided the impetus for the self-defense. What did he do that provided the impetus for the self-defense? And they don't really have anything that makes any sense. So I think there's still a pretty decent chance that this defense will not be allowed to go to the jury. But of course, we'll see. But that seems to be the direction of things. And also this morning, we do have a hearing relating to some potential discovery violations. So we'll be watching that hearing by the defense, potential discovery violations, because they've been dumping documents on the prosecution without any indication about what they are or why they're relevant. For example, just giving them copies of her entire medical records without indicating why those records have relevance to any particular element of the case. So the prosecution's like, could you narrow that down for a little bit? And so far they've been resistant, and so there's a discovery violation now, or a discovery violation hearing, I should say, this morning. There was part one of the hearing yesterday in which the defense basically withdrew their offers of proof. They basically withdrew their evidence so we'll see what's going to happen this morning, whether or not they continue that trend of withdrawing evidence and whether or not there is any impetus to have a fight over it. So anyways, we're going to have potentially a fight over evidence this morning, and then following that we'll have opening arguments. So that will be exciting. So we'll see how it goes. Yeah, discovery is still not done. That is 100% the correct. Yeah, we're still doing discovery because, of course, her lawyers came in relatively at the last minute and have only been on the case for about 3 months. So, yeah, there's still discovery. Plus, they only gave notice of this affirmative defense relating to battered spouse about 30 days ago, which the statute does allow for. It does allow for the notice to only be given 30 days ago. But they're trying to cram it all in at the last minute and not necessarily following everything to a T. So there's some problems there. So good morning, everyone, and I hope that you will enjoy spending some time with me as we watch this case unfold. Should be interesting to see how it all goes. Do we have a witness list? I'm sure there's one somewhere, but I don't have access to it, or I don't know where it is, and I don't really care, really, to be honest. I mean, the witnesses, I imagine, are going to be what you would expect them to be. Some police officers who were there, some police officers who did the interrogation, a medical examiner, perhaps a psychologist, kind of, what you would expect to have. As for her and her witnesses, she has to testify first because she has to provide the predicate for her defense. She has to testify first. She has to provide the predicate for the defense. So she can't have her expert testify until she lays out the predicate. So she has to effectively take the stand first, or at least first before any expert witness. And it's not clear that she has any fact witnesses that she could present first. So it's extremely likely she will take the stand first in her own defense, and then we'll have a fight over whether or not any of her other witnesses are even allowed to testify, which will relate to whether or not the defense can be legally offered or not. So that will be exciting. Good morning, everybody, for sure. Yeah, Right. Well, yeah, she needs to set the stage so the judge doesn't overrule experts. That's right. She needs to provide the basis for them to testify, for their relevance. That's right. So she needs to provide the factual predicate that would allow them to testify. Exactly so. Thank you for being here. Good morning, everyone. Good morning, Tiger Moon. Good morning, Skylar Sanchez. Good morning, Dragonfly. And good morning, Vicky. How are you all doing today? Yeah, lay that foundation indeed, 100%. So we will see how things progress. As long as the foundation doesn't include Jimmy Hoffa, maybe. Good morning, Juggernaut, and good morning, AJ Red Sox. Glad to have you here. Do I know how to say your name? No. So we are just waiting for the hearings to start. Defense should use Chewbacca defense. That's about what they have left. It's Richardson hearing on the first thing. Yeah, that still sounds like what's first. The Richardson hearing. We are still awaiting the court feed to start. They're forcing her to testify. Well, she has to provide the foundation for the defense somehow. And so, how else can it happen except for her to testify? Because she was the only witness other than him, because she was the only one there. So, for example, in Rittenhouse did not have to testify because there were other people who could testify as to what happened, plus the video itself existed. So Rittenhouse was not a necessary witness because other people could testify to the basis for the self-defense other than Rittenhouse, because Rittenhouse wasn't the only one there. There were other people there. Plus, the thing itself was videotaped, which provided a foundation. So Rittenhouse was not a necessary witness. But here, she basically is a necessary witness because she's the only one there. She's the only one there, other than him, and he's dead. So there's no one else who can provide the basis. They're static? Fuck. So there's no one else who can provide the basis except for her. Yeah. I think it's the audio interface. I think it's the audio interface. I don't know. But anytime there's a hiccup, I'll just reset the audio interface because I don't know what else to do. Yeah. So every once in a while, the interface seems to have some static or some sort of problems, and when that happens, I'll just reset the interface. So you have to let me know when that happens so that I can reset the interface because I don't know when it happens because I can't hear it. So yeah, static is back. It's back. This is going to be a very short stream. Check 1 2, check 1 2 1 2, check 1 2 1 2. That did not do it. Okay. Well, is it fixed or is it not fixed? It's okay at the moment? Okay. All right, fine. Let me know if it becomes a problem again. And I'll reset it again, I guess. I don't know what else to do. So we'll see. All right, what else is going on this morning? You're gonna get your paralegal pooch? Okay. What time is it expected to start? 9 Eastern is when it's expected to start. 9 Eastern. Good morning. The mic is XLR. I'm not sure why that matters, but it's XLR. The fact that I told you that I think the problem is the interface should have been a clue. It's XLR. If it was USB, I wouldn't be talking about an interface. So, yeah. What makes me happy? When everything works the way it's supposed to. That makes me happy. You being here and spending time with me makes me happy. It's not the capsule. It's not the capsule. It's the interface. Or it's the sound drivers in Windows, which I don't know really how to fix that issue. It's either a software problem in Windows or it's the interface. One of the two. But resetting the interface seems to help, so I'll just reset the interface. Or get a new interface, one of the two. I might have to run out to Best Buy and get a new interface. Maybe I'll get a new interface during lunch. Go out to Best Buy and get a new interface. We'll see. I'm glad I'm covering it too. Thank you for spending time with me. The jury is 5 women and 1 man with 8 alternates, which seems excessive, but okay. Florida uses 6-person juries, except in capital cases, and this is not a capital case, so 5 women and 1 man. Why the prosecution asked the judge to have SB testify in the narrative? Well, they didn't say that they want her to. They said if she changes her story, they want it to be in the narrative because they think that if that's basically a signal saying that we think it's perjurous. So that's why they said that. They think that if she changes her story, it would be perjury. And so they're basically saying that the defense that it has to be in the form of a narrative because otherwise it would be suborning perjury. So, yeah. Super chats also do make me happy. Thank you very much, Tony P. I do appreciate you providing some donation. Can they amend the charges? I'm not sure what the Florida law allows for. The fact that they haven't suggested amending the charges suggests the answer is no. Plus, of course, if they went first degree, they'd have to have a 12-person jury, and the jury's already been sworn. So no, they can't amend the charges because to do so would be double jeopardy. Assuming they were able to amend the charges, that moment has passed. What do I think about Sarah Boone turning down the plea? I think it's pretty stupid. It doesn't make any logical sense. What was the plea deal? The offer was manslaughter, 15 years. She would have been out in about 5 or 6. So, pretty good deal. Whereas now she's facing a minimum of 22 and a half years and realistically much more than that. So, yeah. Is it reasonable to think he was in the suitcase for 11 hours? Yeah, it sounds about right. He was left in the suitcase overnight while she went to go to sleep. So, that sounds plausible. I'm not sure how much it really matters once he's dead. You know, once you're dead, it doesn't really matter at that point. But sure, 11 hours seems plausible. Good morning. How are you doing? Yeah, it's a pretty bad way to go. I mean, you're in a confined space and suffocating. That's pretty bad. It's a pretty bad way to go. So, my hatred for Sarah Boone is pretty high. Could she get the death penalty? No, she cannot. Maximum sentence is life imprisonment. It's not a capital case. Any other law tubers joining me today? No one's scheduled to join me today, but if other law tubers drop by and they want to drop by on the stream, they're more than welcome to. So, if other ones drop by, then, that'd be cool. Good morning, Amber. How are you doing? Good morning, Carrie. Everyone is streaming? I would imagine so. Good morning. But of course, this is the best stream because it has uncivil law. So that's the only place to be is here because this is the only stream with uncivil law. And so where else will you get this snarky commentary other than uncivil law? No one else will give it to you. Plus, I try to answer your questions as best as I can. Plus, we do have great moderators. That's true. And we do have a cool hat. Yes, other streamers just do not have as cool a hat as me. Some of them have hats, but none of them are as cool as my hat. So 100% there. Plus beef fish, yes. We have cool sidebars. We do have cool sidebars, yeah. Yeah. I appreciate that, Lisa. You know, it was an interesting thing with the Ashley Benefield testimony. I found the reaction of some people to my commentary to be very interesting. Just in how they reacted to it. Um, there were some people who took quite a strong exception to the way that I responded to Ashley Benefield. I'm like, well, I think she's a liar, and I think this is fake, and I think that she is making it up, and I don't think she has credibility, so I'm going to mock the shit out of her. And so, you know, some people are like, well, you're mocking a victim. I'm like, well, that presupposes that she is a victim. And my whole entire point is I don't think she is. I think it's a lie and it's made up. But there were people who are victims, and there were people who see qualities of Ashley's story that resonate with them. And so some of them felt personally attacked, apparently. It's like I'm calling them liars. I'm like, I'm not saying whether or not I believe your story or not. I don't know enough about your story to say whether or not I believe it or not. I don't know. Maybe I would believe your story, maybe I wouldn't, but I would have to evaluate it on its own terms. So I don't know whether or not, I would believe your story, but I would evaluate it and decide whether or not it's real or not. Because what's the alternative? What's the alternative? The only other alternative really is to just believe everyone who claims to be a victim. At which point, of course, you would have to believe Sarah Boone because she claims to be a victim. See, this is the problem. It's like, okay, either we're going to try to determine which victims are actually victims or we're not. If we're not going to determine which victims are not victims, if we're not going to try to make that determination, if we're just going to take the claim at face value, then we have to believe that Sarah Boone was a victim. We have to believe that everyone who says they were a victim is a victim, despite any possible evidence to the contrary, because either we're going to evaluate this thing or we're not. And if we are going to evaluate the thing, then I have every right to say that I don't believe Ashley Benefield. Now, if you believe her, then fine. If you believe her, that's fine, but I don't agree with your discernment. I don't agree with your judgment. But a lot of people took it very personally, so I don't know. You know? And I don't mind if you disagree with me. I mean, I might think that it's kind of stupid, but you're allowed to have an opinion, and I'm allowed to have an opinion. But some people seem to take it very, very personally. So it's like, I don't know. What can you do? Citing. Yeah, Amber Heard, exactly, right. This is exactly the thing. It's like, okay, do I have the right to evaluate Amber? And people got really mad, and this is like the thing, right? People got really mad at me for not being able to like immediately tell Amber Heard was a liar, which is like, that's funny too, right? It's like you can't win. You can't win. It's like you either come to the same conclusion that they do, or you're just a bad person. It's like, okay. So initially, as many of you who are there will remember, initially I had a real tough time like reading Amber Heard. And a lot of people are like, well, it's obvious that she's a liar. I'm like, well, I'm having a tough time reading her. And then eventually the evidence came in and her whole story blew apart. And I was like, okay, so she's a liar and I disbelieve her. But I based it based on the evidence. But they got mad at me for not like immediately disbelieving her. But then with Ashley Benefield, it's like, oh, they get mad at me for not believing her. And I'm like, but in my view, the evidence doesn't support her claim. But they still get mad with me. They get mad at me. So it's like, it's not believe victims, it's believe the right victims. And you better be right. And you better agree with me whether or not they're a victim or not. You better agree with me or you're a bad person. You're blaming victims if you disagree with me. It's like, okay, I don't know what to do with this information. I don't know how to deal with that. So, and I had people send me texts and emails that were really mad about Ashley Benefield. A couple people reached out to me and they were really mad with the way I mocked her and were really mad and like, I want you to go back and reevaluate and put your opinion aside and really think about this. And, because, the lawyer on civil didn't show up that day. And I'm like, I don't know what to do with this information. What are they showing? A wall. Someone went by. Yeah. Melanie Little's chat in particular was very mad at me. And by the way, I'm not mad at Melanie Little. I don't know how she feels about me, but her chat in particular was very mad at me. I believe that there is a number of people in Melanie's chat who are victims of domestic violence. And so a lot of those people seem to believe that I was attacking them and their story. And it's like, well, no, I'm not. I don't know enough about your story. But tell me your story and I'll decide whether or not I believe it or not, I guess. Which I guess is definitely not what they want to hear. Right? But it's like, okay, what else can you do other than try to evaluate it? It's like, what else can you do other than try to evaluate it? It's like, can it possibly be the case? Can it possibly be the case that everyone who claims to be a victim of domestic violence, for example, in Melanie's chat, really is? Can it be that they're 100% telling the truth? Well, no, that's just not realistic. They're people. Some of them are lying. I don't know which ones necessarily, but I'm pretty sure some of them are lying. Some of them are exaggerating. And so what else can you do other than evaluate it one thing at a time and try to evaluate it based on its merits? What else can you do? But that was the wrong opinion or something. I don't know. Why are there like so many people at the judge's bench? How many people do we need at the judge's bench? Damn. Does he have like 5 clerks? Holy shit. But again, no hard feelings to Melanie. No hard feelings to Melanie. I have nothing against her. So I want to make that absolutely clear. And I hope that we can collaborate again. I hope that my opinions were not so reprehensible that, we can't be friends. Because I don't know what to do with that information. It's like, I don't know what to do with that information. If it's like, what else can you do? What do you want me to do? Just change my opinion? It's like, I just don't see it that way. I don't know. But it was an interesting phenomenon, to be sure. Yeah, someone who has family and friends at DV, I can tell you we wouldn't care if people believe them or not because we know the truth of the situation. Fair enough.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone. Kevin Beck, Sarah.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person, so we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Your Honor, most of them include billings, observations by the medical personnel, so it doesn't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety, and then I've identified
As always, audio balance is going to be a thing. Plus, not for the least of reasons that the attorneys are not always speaking into the mic, and I
Of
can't
those
fix
119
that.
images, how many are being
But I'll
sought?
turn down my audio a little bit, so hopefully it'll be a little
15?
bit more balanced.
Okay, thank you.
So
State
I cut my
response-
volume to about half, so it's about 50%. So hopefully that will be a little bit more
These are
balanced.
all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first two that they list are pages 9 and 10 out of 111, and I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp, so I had to, I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those two pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63, it appears to be repetitive, but we don't have any particular objection to page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically,
They're doing the
asking
hearing
for
first
pages
before opening
26 and
arguments.
48 to be
They're doing
included.
this Richardson hearing
thank you.
first, and then they'll do opening arguments.
The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens
Richardson
or Mr.
hearing
Beck,
is
are you
a
in
discovery
position to
misconduct
advise
hearing.
when these documents were first requested, when they were received?
The state
and when
is
they were
arguing
sent
that they've been
to the
unfairly
state?
surprised by the
Specifically,
evidence.
any documents pertaining to Exhibit 2, the Advent Health Winter Park records.
Judge, I did check with my secretary, Margaret, and my understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release, we sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late, and I think it was yesterday or the day before, that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from the Workforce Advance Building Department, apparently it's a separate subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for receipt of those, so we received those. So it's all been within a couple of weeks, plus we had to.
No particular FOMO about not being her lawyer. I'm quite comfortable here in my apartment in Houston, to be honest. No FOMO by not being her attorney. No, I'm good. Yeah. Yeah, more like Romo. That's right.
Any
yeah.
further argument or positions with regard to the
Yeah,
Richardson
that's-
analysis,
That's,
Mr.
that's
Jay?
much closer.
For purposes of this hearing, I'd like
Yeah.
this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 20th.
Well, the court sound is what the court sound is.
Any
I can't
objection?
fix it.
All right, what was pre-marked A for the
So-
purposes of the Richardson hearing will be received
It
without
is what it
objection
is.
as states 1.
All I can really do is change my audio levels. The court audio is already maxed out. So, well, although theoretically I have a booster, I think. Let's see, because I think, hold on. I think I have a booster somewhere. Yes, I do. Hold on.
There was just a reference
Oh, I can boost it a
pages
little.
were all marked up by the defense. There's no
Haha.
markings. The issue
I
and
can boost it to
confusion that the state
300%.
attorney's office still
It's
has,
exciting.
though, is page 68 of 81 of these original 81 documents.
400%.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes, sir.
entered as 1, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that, and so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just, at this point, I have not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119-page PDF and you make it word searchable, you just put in the magic word, and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again, and I'll provide any
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's Fifth Amended Reciprocal Discovery Exhibit List. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seen exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going
Good
to
luck.
be entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, of prior events of violence committed under that instruction, under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did quote up a couple of these on the justifiable use of non-deadly force.
That does not answer
This
my
has
question.
got to be the most unique self-defense case of all time. The self-defense
Okay.
weapon is a suitcase, basically. That's got to be a first. Normally, it would be like a knife or a gun, maybe a baseball bat, maybe like a tire iron, maybe a vase. Suitcase has got to be a first.
No, I can see it, sir.
And the other one is a reasonable doubt is not in there. Possible doubt, speculative, imaginary, or forced doubt is the standard instruction on duty.
Does this
What's your
mean that
position with
does this
regard to
mean that
those two, Mr.
suitcases
J?
now have to be
Judge,
registered
opening
as deadly
statements, we
weapons?
should be discussing
Do I
what
need a
we
do I need a
anticipate will come into
do I
the
need a
trial.
permit
That's going to
to
be enough
open
of a
carry the
minefield.
suitcase?
It really shouldn't be about.
Florida doesn't
law.
have
We'll
open
both
carry.
have an
Are people still
opportunity
allowed to
use
take
the actual
their
jury
their
instructions,
suitcases
which we have not decided upon.
in open? Or do they have to put like a
We will have the
cloth over
opportunity
them?
to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be
Assault
doing that at this
suitcase.
time.
That's
It's not
right.
the role
That's
of
right.
opening remarks.
All right,
Any
people
other
in chat,
response?
please
Doing this 35
describe
years, I've
the
had these
features
boards, I've
of
used these
assault
boards in opening statements, I don't
suitcases.
know how
What
many
features
times.
designate
I've said
an
that I
assault
would waive
suitcase?
introducing
I will now
one
take your
specific
suggestions
to
in chat.
self-defense. But reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please?
Detachable magazine.
Well, here's the first problem.
What is
That's
a
the wrong
detachable
instruction.
magazine in the context of a
Florida Supreme
suitcase,
Court
though?
revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all
Oh,
doubt.
this is a good one.
Reasonable doubt is not a mere possible, a
Wheels that
speculative,
move, allowed to move
imaginary,
side
or
to
forced
side.
doubt.
That's good. I
Such a
like that
doubt
one
must
very
not
much,
influence
Steve.
you to return
Plus
a
1
verdict of
point.
Not guilty.
That's a good
if
one.
you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence. There's not an abiding conviction of guilt, or, if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone for the arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from when
Assault suitcases can hold more than 10 articles of clothing. That does sound really dangerous. That sounds really dangerous. Multiple grip points. Yeah, I'm feeling the assault suitcase. Yeah. You only get one compartment. No one needs more than one compartment. Yeah. Wheels larger than 2.5 inches across. That's very good. I appreciate the reference. That's very good. I like that. Very nice. +1.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case, because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we
Buffer
get
wheels.
the evidence. What we should be doing
To limit
is
noise.
explaining to
That's
the jury
good.
what we believe the facts
Yeah,
are going to show
I like
and the
that
inferences
one.
that they can draw from them,
Buffer wheels to limit the noise.
and argue the law.
Silent zippers.
Last bite at the apple, sir.
Yeah.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and
Do we need assault
I
suitcase
understand
stickers
the
on the
reason
merch
for
store?
that, depending on the
Why
evidence
not?
that comes in, but there's
Why
standard
not?
instructions that are going to apply
Why not have an
throughout.
assault
And this is just
suitcase
giving
sticker?
them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Why does the judge have what I assume are 4 clerks sitting at the bench? That just seems like, that seems a bit excessive. First of all, for a trial judge to have 4 clerks is a lot of clerks for a trial judge to have in the first place. That's a lot for a trial judge to have 4 clerks. There are justices who don't have 4 clerks. I'm trying to remember how many justices a Supreme Court justice, or how many clerks a Supreme Court justice gets, and I'm not even sure it's 4. I think the Chief Justice might get 4, but I'm not even sure that the Associate Justices get 4 clerks. Why does he need 4 clerks? Second question, why are all 4 clerks sitting at the bench? That seems excessive. That seems excessive. How many clerks do you need, man? I'm sure there are judges who don't even have a single clerk. And this guy's got 4 of them for some reason. Holy shit. He's the head of a mock trial team. That's who these people are. They're students in his class. Okay. That's interesting. How many clerks do you need? Jeez. That's the judge's personal clerks, by the way, not to be confused with the court's clerk who sits off to the side, which every court would have, right? So there's a clerk whose job it is to like manage documents coming in and out, right? They're the ones that stamp the documents, receive the document, you know, give it an evidence number, right? So that's the clerk for like that. The clerks I'm talking about are the judge's personal clerks. They're his valets. They work for him personally as opposed to working for the court. And it's like, okay, that seems okay. How many clerks does it take to run a court? I know. The Chief Justice gets 5 clerks and the Associate Justices get 4 clerks. Okay, fair enough. So this is what I'm saying, though. Associate Justices of the Supreme Court have 4 clerks. They need 4 clerks because they have so much shit that they're doing on the law. They need 4 clerks. Why does this judge need 4 clerks? What are they doing? All right, chat. Now I'd like your participation as to what you think the 4 clerks are doing. Why does the judge need 4 clerks? Please provide your answers in chat now. I will now take your suggestions for why the judge needs 4 clerks. Bonus points if you're related to the case and or the suitcase in particular. Takes 4 to screw in the light bulb? May well do. May well do. You think one is going to climb into the suitcase as a demonstrative? Pog. I'm not. He can have students who witness the trial, but why do they need to sit at the bench? That's just weird. As a lawyer, I'd be like, who are these people? Who are these people, and why are they sitting at the bench? You think they're there to protect the judge from Sarah Supermaning it? Sarah doesn't seem like the Supermaning kind of type. But then again, maybe you never know.
Identified as A, Defendant's Exhibit A, purposes of a demonstrative evidence or further statement. There's a picture of Sarah Boone that was taken by law enforcement on one of the incidents involving arrest.
To give the judge 6 peppermints? Love it. Maybe that's why, that's a good point. Maybe that's why.
Next photo.
Maybe that's why Sarah Boone asked for exactly 5 peppermints. Maybe that's why Sarah Boone asked for exactly 5 peppermints. She wanted one for each clerk and for the judge. That's it. That's why she wanted 5. One for each clerk and one for the judge. These aren't really for me. These are for you, Your Honor. Pog. Boone is definitely taking the stand. She basically has to take the stand. She's a necessary witness to this, so she has to take the stand. So whenever that happens, that'll be pretty hilarious. By the way, since someone asked me earlier in chat, did we ever decide on an official drink? We did. We decided on Dr. Pepper with Kraken rum as the official drink for the Sarah Boone trial. So if you'd like to get that over the weekend, go to your friendly liquor store and get yourself some Dr. Pepper and Kraken rum so you can have the official cocktail. Then, yeah, that'd be great.
It shows where Jorge Torres poked her with a curtain rod.
Am I covering the entire trial? I'm planning on it. I'm kind of looking forward to it, to be honest. It's been a while since we've had a live stream trial. And I'm kind of looking forward to doing it for a couple weeks. It's a nice little reset, you know, after I've been doing these edited stories and stuff. It's a nice little break. So, yeah, I'm kind of looking forward to doing the entire trial.
And Sarah Boone's phone. The state took custody of the phone. The state had the photographs. The state provided the defense and discovery with these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the normal size pages of the photographs and then using these as a demonstrative aid to show the jury clearly knows.
Look at this photograph. Every time I look, it makes me laugh.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens.
Yes, Sir Judge, and I sent you some case law.
When did you send it, sir?
This morning.
I have not.
That's
received
another
it.
reason to watch Uncivil as opposed to any other stream. Because Uncivil, I think, stands alone as occasionally breaking out into song. So there's a unique value proposition for you. Uncivil law includes singing time sometimes.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, I'll check.
Is it just these two cases? I've been provided Alsager v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Lowe v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs.
I will be your hero, baby. I will wash away your tears. You
In the
are my
Alcaguer
everything.
case, which is the 2021 case, Supreme Court, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record. The 2018 case, Supreme Court.
Guess who's
Florida,
back? Back
again,
again.
trial court acted within its
Uncivil's
discretion,
back.
allowing a demonstrative
Tell a
exhibit in
friend.
that case.
Guess
it was a
who's
murder
back?
prosecution.
Guess who's back? Guess who's back?
Trial
No,
court
no,
acted
no,
within
no.
its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body, The mannequin was used to set out the circumstances.
We only
of the
have
crime
6
and to
jurors
attempt to
because
establish
Florida.
aggravation. The mannequin was
There
used
is
to
no other
demonstrate
answer to
location
this
of the gunshot
question.
wounds,
We have 6
angle of
jurors
the
because
impact against the
Florida.
skin, the incapacitating nature of each gunshot wound.
That ends the
Rising of
legal
the
analysis.
trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm. I think the two instructions would read, find that Sarah Boone, who because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres, you may consider this fact
Yeah, I think that's probably the right.
of Sarah Boone.
I think it's probably the right layout.
Goes on to say, you find at the time of the alleged second-degree murder, Sarah Boone knew that George Torres had committed an act or acts of violence. You may consider that fact to determine whether Sarah Boone reasonably believed it was necessary for her to use another.
The assault suitcase sticker is waiting my approval. Excellent.
Belief
Let's do it.
that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Let's see what we got.
Thank you.
Oh,
Any
motion for
response, State?
Yes, sir.
Yes, sir.
Judge, the standard is.
big dicta.
It is
I
your
like the big dicta
discretion,
energy.
and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections
Assault suitcase sticker. Love
are
it.
this.
Very, very
With
cool looking
A,
sticker.
which is beneath everything
Love it.
now,
Very
but
good. I'll approve
the
that.
bloody ear from
Nice
the prior
sticker.
incident. I believe
All
that
right.
it's from a
Assault
body
sticker
worn
is now
camera,
available for
and I think
sale.
he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into
Yeah, there you
things in
go, Bob.
opening statements.
The only suitcase
don't end
used
up
by
coming
SEAL
into
Team
evidence.
6.
And when the defendant does that,
Love
under
it.
King versus State,
Love
the
it.
state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect.
Very,
that to be
very
coming into
scary,
trial, so
Britt.
we're objecting
Very,
on
very
that separate
scary.
ground. And then
Don't break
returning
into
back to
Britt's
C,
house. She's got a suitcase,
D,
people.
E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them
A
ourselves.
short-barreled suitcase.
Through the digital evidence.
That
There's no
actually sounds
hiding those things.
counterproductive
If
for a suitcase, to be quite honest.
we meet the threshold
Thank
for
you
this
for
sort
the
of
chat
evidence
anyway. Got a
coming in.
laugh out of
Could
me.
you identify those for me? I'm trying to keep.
Should
notes
we
of
start the
memory.
National
Yes.
Suitcase
It
Association?
was C through I inclusive?
Yes.
Thank you.
B is the only one that is not
Yeah.
a photograph of prior violence. I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want, but in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this.
Ah.
We are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, it was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that prior?
No, what I ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there is going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B?
So look at B, which one's B?
It's her on the back porch with the two dogs.
Judge, not only did he abuse, George Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce, that they listed as exhibit.
Flowers and paintings?
I thought for sure we put this on there, but the relevance of it is not only.
Okay, guys, theoretically, at some point today, we're supposed to have opening arguments.
He would threaten to abuse the dogs, to control Sarah Boone.
Okay, thank you.
Is the sound crackling again? Do I have to reset it again?
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, the purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law. And that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear.
The crackling
Before a
comes and
defendant may
goes?
introduce evidence of the victim's character, he must first show that there was an overt act by the victim
Okay.
at
If the
or about
court
the time of
audio
the
is
incident
crackling,
reasonably
that is not
indicated a
me.
need for self-defense.
I'm only
I
worried
understand your
about
good
my
faith
audio
belief.
crackling.
I take
If the
no
court audio
position on
crackles,
whether
it
or not you're going to make
crackles.
it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some
You're getting
incidents that may have
crackles from
happened,
me.
but I'm not going to allow the
My audio
photographs
is
at this point
fine.
in time for those reasons.
All right, so
for your utilization of them
there's
in
a
opening
dispute.
statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
I've got two other issues.
Really?
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute Suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach eventually.
Okay.
Oh my God.
With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. What's good for the goose is good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses
Fair enough.
or through
I like this.
demonstration and publication
I like
after
this.
that evidence is admitted.
I like this as a ruling. It's like, okay, I'm just going to have an across the board rule. And it's within my discretion as the judge. I can allow it, I cannot allow it. And so, you know, you were upset with the state wanting to offer their exhibits and their things. And so, like, okay, just turnabout's fair play. No one gets to bring in evidence into the opening, which, you know, fair enough. It's obviously not evidence yet. It hasn't been offered. So it's discretionary. So the judge is like, you know what? I'm just not going to allow any of it. You can talk about it. You just can't show it. You can show it, you know, when it comes up in trial. You just can't show it now. And so I'm just going to do this across the board and have it be even. Like, you know, just make this simple. Make this simple. Cut it off. I like this very much. This is nice.
Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
All right. Yeah. Good ruling, in my opinion. Good ruling. Clean. Clean is good. Look at this photograph. Every time I make it makes me laugh. Do 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 do. Thank you for the 400 of you who are watching. Appreciate you spending some time with me. For any of you watching on Twitch as well as X, looks like we got a couple people. It looks like we got 5 people watching on Twitch, and we got some people have at least viewed it on X, plus the 400 of you currently watching here on YouTube.
Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense. No, sir. All right.
Great.
Let's stand and bring in our panel.
Woo! Bring the jury. Bring the jury at last. B-Fish is ready to hear the case. B-Fish is ready to hear the case.
Good morning, y'all may be seated. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Can the parties approach for a moment?
Exciting. We're finally going to hear them actually lay out their theory of the case for real. We've heard teasers about it, but we're actually going to hear them actually lay it out. And of course, we will give them a rating as we do. We will give them a rating as we do on the quality of their.
Members of our jury, good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. And then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment? And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
Yes, double jeopardy attached. Double jeopardy attached yesterday when they swore the jury in. So jeopardy has attached. Now we're talking about an elevator. Did you take a lift with somebody? Did you have a snog?
All right, thank you both for your honesty. I appreciate that. It's something we talked about earlier this week. That's the one thing that we required and asked of you, is just to be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that would impacted you or influenced you in any way, to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir.
Thank you.
All right, guys, here we go. Sell me.
Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida. is a suitcase on the ground, face down, with the zippers facing the floor. You will hear, Sarah. The defendant will say, for everything you've done to me. Sarah. For everything you've done to me. Sarah. Fuck you. And then the defendant laughs. Sarah. Fuck you. And the defendant laughs. Sarah. Stupid. Sarah. That's my name. Don't wear it out. Sarah, I can't fucking breathe, baby. Seriously. Yeah. That's what you do when you choke me. Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres
Stepping away from the microphone. Damn it!
Well, the next morning, the defendant wakes up, late morning, or perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Mrs. Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, he took his little legs out. At some point she makes that statement. And tries to resuscitate him. Hears gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. Then the next thing she does is she doesn't call 911. She calls Brian Boone. Now, who's Brian Boone? Well, Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday.
You know, like Law and Crime and these channels really should invest in some shotgun mics or something
School day for their child that they share in common.
so that they can just point the mic at the person when they're walking around and get audio that way.
The weekend, no co-parent. And that weekend included Friday, Saturday, Sunday. So it's got 3 scheduled. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian.
Does Law and Crime not know about shotgun mics?
So February 23rd, 2020 was a Sunday. And now he's led into Monday, 2020. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm see in the phone record, he calls her, and then she finally calls him back.
No, I have no objection to the lawyer using the space. The lawyer is doing his job, and he absolutely should use the space, and he's not actually doing it super well, to be honest. He's just kind of standing there and just kind of gesturing. He's not really effectively using the space, but I appreciate him, doing that. My objection's more at law and crime for, not understanding that directional mics exist.
See that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911.
Yeah, you could also put a condenser mic on the ceiling or something. You could do a lot of things like that, yeah.
Outside, though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office and autopsy. What the doctor found was what you would expect after being left in the suitcase. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head and you stuff with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space.
Can I boost the audio a bit? No.
It's close enough.
I've already boosted the audio of the court 600%. I cannot boost it anymore. It's at its limit. And if you want me to reduce my audio more, I can, but obviously the audio of the court's variable. If they're next to the mic, I can't fix I can't fix it. So no, not really.
She'll use words like hematomas. We'll help her understand for you all that means bleeding under the skin and blood. What you expect from a bruise.
If I lowered my audio, then the court would just completely blow me out when they're next to the mic. I can't win.
So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. And it's more of the same as what we heard on the 911 call. Hide and seek. It was good. I fell asleep. What happened? A few hours later, the detectives from the homicide unit of the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone
I could do interpretive dance.
off of a counter that was found at a suitcase of Mr. Torres. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery.
We could do better,
The
friends.
bottles, plural, are in the trash.
We could do better.
It started about 4 p.m. after Mr. Torres went.
Friends don't let friends drink basic bitch Chardonnay. We can do better. We have the technology. That's my PSA for the day.
To the store, puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over.
Could I recommend, for example, just like a nice Sancerre? You know, how about that? That'd be good. Some white Bordeaux, maybe. That'd be nice. Maybe a Pinot Gris. Or how about an unoaked Chardonnay? Those are nice. We can do better, people. Although, to be fair, it's not white Zinfandel. White Zinfandel is a crime against humanity. So, there's that. But, you know.
Over from Boer wasn't even half full, so the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same.
Or here's a fancy one. How about Ungi Blanc? Try that at your store. Ooh, something really fancy. We can make this more creative.
Many of us may envision what you would expect at a restaurant. Those are 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces.
Okay, 1.5 is called a Magnum, right? Yeah. Okay.
Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday,
I know my wines,
February
guys. I'm just
20th.
saying. I know my wines, and I can do some reasonably good wine pairings. So, you know, it's one of my qualities. I used to go to wineries all the time when I was in Northern Virginia. So I love a good bottle of wine, and we can definitely hang and talk about wine, and we can definitely make things a little bit more interesting. Yeah.
22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine.
Thank you.
So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context,
It's a healthy amount.
Having wine, enjoying each other's company.
3
At one
liters
point
of
we played
wine.
hide and seek. She says she didn't zip it up all the way.
That's a big day.
There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it, doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each
No,
other. where
no,
we
this
could
is a
find each other
mistake.
the best.
This is a mistake, Jill in chat. Look, if you're doing the Woodbridge wine, just save yourself the effort and just get yourself some $2 chuck. Get yourself that, and that's going to be, it's going to be cheaper and actually probably arguably slightly better. So just go to Trader Joe's and get yourself some Chardonnay there. It'll be like $3 a bottle, and it'll be a little bit better experience, probably, all things considered. So, you know, hey, just saying, man.
When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she,
If you're looking for a nice bottle that's just like nice to have, the Conundrum makes a really nice red and a really nice white. That's what I have in my fridge right now. So I have Conundrum red and Conundrum white. You know, it's not particularly exceptional, but it's only like $20 a bottle, and it's very, very good and very interesting, and provides a more interesting experience than like just like typical whatever. So the Conundrum white and the Conundrum red are interesting if you're looking for a bottle. Also the Josh Reserve Cab Sauv is pretty good if you want like just an easy supermarket wine. Those are good choices.
she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean Orange County Sheriff's Office in part, is going to her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again, and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the two videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. Defendant's response,
Damn,
bless
shit.
you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better.
Ooh,
Torres. Referring to Mr. Torres.
that doesn't sound great.
And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door we shall not enter without permission and invitation. Halloween in like 13 days.
What are you talking about now? I'm sorry. How do we get into a discussion about vampires? Okay.
We're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning,
Is the defendant a vampire?
we're going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony will be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital.
All right, wrap it up.
He's a man who had serious alcohol.
Wrap it up.
And I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship,
This isn't quite as well organized as I'd like.
it's one thing to have a bad first date.
It's not like horrible, but and also we're losing a little steam here at the end, I have to be honest.
There's a second and a third. Now these days are at bars, and there's nothing wrong with that. But
The problem he said that's the case. And he's still talking. Like, no. When you say that's the case, that's when you sit down. It's like, but we're still talking. And we seem to be wandering a little bit at this point. It's like, okay.
up, she's going to tell you, I suspect, or you're going to hear that she said one way or another. It's one thing or the other. Like I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price.
What the hell are we talking about? We're talking about vampires and cigarettes.
There were injuries that the defendant is going to attribute to the victim causing them. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview happening about a month before this. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting, playing around in medical evidence. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in,
Someone's got to play.
going to have the opportunity to
Someone's got to play the Oscar,
lead the tour in this room labeled
speech is over music.
past history.
There should be a button a judge can push to play the wrap it up music.
But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector,
Again, that felt like the last sentence, right? Just now, right? It felt like the end. But we're going to still keep talking. So you're signposting. This is now the second time You've signposted the end of your speech, and you're still going. Okay.
There are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during
Check 1 2. Check 1 2. 1 2 1 2. Check 1 2.
subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5. Diagnostic Statistical Manual, version 5. It's text revision or something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it means these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. It gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts, because it's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence.
You know what else it could be? Also, in addition to the interface and the software of my PC, it could also be the browser interface that I'm doing inside of Chrome. Because normally I don't broadcast within Chrome. Normally I broadcast within OBS. So it could also be the browser-based interface I'm doing. So after lunch break, I'll switch to OBS. It'll allow me more control over my layout anyway, which will be just as well. And it will also allow me to a little bit better manage the audio. So after the lunch break, I'll stream in OBS. And hopefully that will address the issues. At least some of them.
But turning to the facts of our case, but you're going to decide the facts.
Please stop talking, by the way.
Ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction as part of that. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house,
Please stop talking. Please wrap it up.
brand new JDC pipes, this sucker's good to go. I'd rate it at $600,000. You're not going to take that home inspector's report unless they lift the hood.
What are we talking about, and why are we talking about it?
You want an expert to get reliable information. An expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the disorder. Even if it's the patient, the client that is saying all these things happen to her. You gotta find
Excuse me.
check reliability. particularly in circumstances that we discussed. Another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs. And that's just their day, and they get over it. They live their life and fight another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, it doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to Ms. Boone. But we'll talk to her about
Fox 35 has good audio.
make that conclusion. We'll talk about some other things and take that journey together if we get there. But at the end of the day, after you hear all of the evidence in this
I'll switch for the defense's argument.
straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state submits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
All right. We'll switch audio sources. From what I could hear, C minus. A little bit disconnected, unorganized, especially at the ending. We had multiple different endings for some reason. It went on too long. It rambled. We had very weird analogies. Didn't really work for me. All right, let's switch sources to Fox 35 Orlando. Apparently has good audio. We'll give them a shot. Let's give Fox 35 Orlando a shot and see if they have workable audio.
The photographs, the videotape,
Holy shit.
and come to a conclusion.
I'm not sure how much better their audio is, but we'll give it a shot.
Now let's talk about this day, February 23rd.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you.
We'll give this a shot.
You may proceed, sir.
This does not have closed captioning, though. This does not have closed captioning. So just to let you know, they do not have closed captioning. So, okay.
My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Beck. Now, this is going to be a several-day trial. Obviously, today, Monday, Tuesday, Wednesday, we're not sure, but we're trying to make arrangements for witnesses to fly in, expert witnesses and whatnot, and we'll know more probably within the day or Monday, so you can plan. But I know your focus is on this case because you took an oath to do so. Ladies and gentlemen, there is no higher call than to write a will. No higher call than to write a will. And we're going to ask you to go to the case to write this will. And find Sarah Boone not guilty because she was justified in the force that she used to defend herself. If that force was reasonable under the circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism Now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that.
I can imagine it.
It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that Jorge Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years. And there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. In considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence. The credibility of the witness. The photographs, the videotapes. And come to a conclusion.
Okay. All right. I'll weigh their story against nothing.
Let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time.
Yeah.
Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex.
Publix makes great sandwiches, by the way.
Drove over there. So you're going to see a videotape.
I
of
miss Publix sandwiches.
those going in the store,
They make a great
About
sub
noon.
sandwich.
and they come out with one of these larger bottles of the wine.
I want a Publix sub sandwich right now, damn it.
There's a receipt.
They're so good.
And the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And
Sometimes those episodes of disagreement wind up you locked in a suitcase. Am I right, folks? I mean, who are my married couple? Who are my married couples in chat? Which of you married couples have never
in certain situations,
locked each other in a suitcase before? I mean, you know, it happens, right? Common
but when
experience.
his level of intoxication gets to a certain level is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the line. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex, and Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then there'll be that bottle. Will be in the-
I no longer have a special lady in my life to lock me up in a suitcase.
Well, when he comes in with the second
It is one of the
bottle,
hardest
Sarah-
parts of my
Sarah
day.
knows.
The hardest part of my day is I no longer have that special woman to lock me
She
up into a
knows this
suitcase.
means he's going to get to another level.
I miss
of
it.
intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs.
Just to remind you, this is the defense
now.
now.
Shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But
I'm definitely getting a sandwich today for lunch.
cool.
100%.
Broken off.
I'm definitely getting some sort of Italian
And they
sub.
attached a little paper clip.
Yeah.
It's got the rubber around it. And that's how
I'm definitely feeling I'm definitely feeling a sandwich today.
Well,
for
she comes
lunch.
down the steps. She sees him getting in and settling in the suitcase. So she walks over there, and they see each other. They smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And
You can't hear the attorney?
they
Well,
carry on. She
it is
sits
what
on
it
the
is.
couch, and at some point, he says, "I can't breathe."
I can lower my audio a little bit more.
His face is facing the zipper. And
I'll lower my audio down to 50%, see if that helps at all. But still, it's an audio
She
management
doesn't
problem.
know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience.
Yeah, captive being the
Physically,
key
they're
word
the same
there.
size
You
as
know,
him. He's much smaller.
normally when we use the phrase captive audience, we don't mean captive quite so literally. Captive would be the key word in this sentence at this point. Yeah.
than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get out. He has to sit and listen. It's a unique form of physical restraint.
It is unique. I mean, I think we concede that. We all concede it's fairly unique. We'll agree on that much.
You'll see the video, it's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George is, the suitcase is flipped upside down. The zipper's on the bottom. 11 minutes later, Sarah has flipped it right side up,
You're a B.
open for him to get out.
Talk amongst yourselves.
And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain. But there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving a bat. Her son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loved you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. The prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak. Vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect.
Yep.
And, you know, she goes, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George.
Mosey's.
She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase.
Wow. That's an interesting. That's interesting. Okay. Oh my God.
She unzips
Oh
it.
no.
She
The
gets him out.
suitcase.
He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband. Really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at. Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. He said, call 911. She calls 911 within a minute, two. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible.
Yeah, I think that would be a good thing to think. That would be a good thing. Maybe somehow I'm responsible. Yeah.
Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And you know, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Of course, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We're bringing.
This is not good. This, like, I don't know, homie style has worn out its welcome. It's not doing it for me. Not that he has anything to work with. So maybe the homie style is deliberate because a more focused approach would be questionable. So maybe this is just the best of bad options, but it's worn out its welcome for me. So yeah.
Get back to you more. Well, they end up having a conversation with the female detective, homicide detective, Copsall is her name, Chelsea Copsall. And they end up, Deputy Copsall was pregnant, or Detective Copsall was pregnant, said, end up, hey, we're not gonna bring your phone, I'm not feeling good, pregnant, can you come to the sheriff's department? Which Sarah Boone was telling you, that was what I was going, that's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up already. And they were going to confront her and try to get her to confess based on the 2 videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there.
She is
They
so
said,
guilty.
Come up here, we need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand
She doesn't
that
though.
she's justified in using the force that she used.
She isn't though.
She doesn't. I wasn't there to advise her. No lawyer was there.
Well, that's on her, and
So
I'm
she
not sure a
lied.
lawyer could have helped her out very
And
much.
you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent.
I'm definitely getting some sandwiches for lunch.
So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional.
No. That only works if we got him into the suitcase in the first place as part of the self-defense. Right? That only works if we got him into the suitcase in the first place. It doesn't work. You're trying to bootstrap this. Right? If somehow using the suitcase was in furtherance of the self-defense, then I guess, but that isn't the argument. So you can't bootstrap this. You can't say it doesn't make sense. It would be, I don't even know what the equivalent would be. It would be the equivalent of me saying, I shot you because there was a gun, and if you had reached for it, you could have hurt me. I don't know. It doesn't. I don't know. It's some stupid.
Self-defense, nonetheless. Now, as I said, the struggles that occurred, many of them involved.
I shot you because I knew you owned a gun. Something like that.
You
Yeah.
can actually hear from some of the police officers. Maybe some
Something like
body
that.
cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress. You know, we're here today, full packed courtroom.
Yep.
Judge Craddock's here, but you're the most important people,
Yep.
because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial.
Uh-huh.
Because of that, she doesn't have to prove anything.
She kind of
That's why the
does,
state
though.
went first in jury selection. That's why.
She kind of does. I mean, she at least has to put forward the initial proffer for the self-defense, because it's an affirmative defense. I mean, ultimately, the state has to disprove it, but she does have to provide any evidence at all that it's self-defense. And I'm having a tough time with that one, to be honest. So, yeah.
Why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case.
Really? Oh, no, I'm pretty good.
But the most important thing is not to rush to judgment, to keep an open mind, and understand there's two sides to this case. There's their side and
Uh-huh.
our side.
Okay.
So
Sure.
you can't form any fixed opinions.
I don't know. I have some opinions.
That's hard to do, as Mr. Henderson said in open or in jury selection.
I have some
Extremely hard to
thoughts.
do.
Not on the least based
Now,
on
you
your
can give some
opening, by the
testimony.
way. Your own opening isn't helping with the
Information
thoughts and
that's-
feelings.
Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger.
Yeah, but it still has to be
Victims of
objectively
repeat
reasonable.
violence may fear death in a situation others would not.
Yeah, okay.
After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty,
Uh-huh.
because it's the right thing to do.
Oh, is it now? It's the right thing to do. Okay.
Thank you, sir. Can the parties approach for a moment?
Well, exciting. Very exciting.
Been listening to opening arguments in the Suitcase murder
Shut up.
trial.
I don't care about your commentary.
This is for what minutes?
I think this is the friend, I guess, who came over.
Mr. Torres, for the writing of these sworn please, do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, good morning. You could be seated. And once seated, if you'd state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
6 or 7.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, I'd say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Pretty close.
Would you see him pretty often?
I would try not to go there too much.
Who was George living with at the time that he passed away?
Sarah.
And without getting into many details, what was your relationship like with Sarah?
We wouldn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes, sir.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it. We just hung out.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear. but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
No.
All right, sir, let's go back to this phone call that you were talking about that was on February 23rd of 2020, and that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No. Because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I could tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have it. If I
Well, that
You may,
was
sir.
not particularly informative, but okay, fine. Seems like a slightly strange witness. I don't think we really got much from him, to be honest. Not sure there's really much of value there.
Sir, other than siblings, do your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Seems like a strange witness to start with. Didn't really get much from it.
Raise your right hand and repeat sworn. Please, do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's Devinjamro.
Hello.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D's in Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
What the hell is going on right now?
Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
He has no way he can possibly answer that question. He has no way he could possibly answer that question. Do they fairly and accurately reflect it? He would have no idea unless he personally checked them out. And even then, how would he remember? So, bad question or bad answer, one of the two.
This time I'd like to move what's previously been marked for identification as States D into evidence.
Any objections?
No objection?
What was pre-marked as States D will be received into evidence without objection as States 1.
I mean, he have no reason to disbelieve them, but he has no reason to know that they're accurate. In particular.
Your Honor, may I approach the witness who's been previously marked for identification as States J and shown to defense?
You may.
Thank you for the 300 of you spending some time with me.
Sir, I'm showing you it's been
Tell your
Okay.
friends.
Can you take a look at that disc?
Yes,
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes,
And in the normal course of business, are the videos from those surveillance cameras kept?
yes,
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
yes,
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
they do, yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification, as states J, into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day.
They're not going to play the video? With the,
State, you may call
okay.
your next witness.
It seems odd.
Joan Williams?
They didn't ask like what was on the receipt. They didn't ask to play the video. Strange. Strange. Just, is this a receipt? Yes. Is this video? Yes. Very strange. Very strange.
Raise your right hand to the line, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the Orange County Sheriff's Office,
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
I've ordered some Jimmy John's.
Your Honor, may I approach the witness which has been previously
got-
marked for identification as states L.
Got myself a
shown to defense?
Italian sub and a tuna. Tuna.
Ma'am, I'm showing you what's been previously
Tuna.
marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
What was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Right. Can this witness be released?
Yes, Your Honor.
Yes.
Thank you, ma'am.
Again, very strange.
Can the parties approach momentarily?
Just have the witness there and be like, I'm a 911 operator, but no, we're not going to play the 911
We
tape.
are watching
Shut
the
up.
State of Florida.
I don't care
v.
about your
Sarah-
damn ass commentary. The only commentary that matters is mine. I'm the best commentator. All other commentators are weak.
Raise your right hand to be sworn. Please be swear or affirm that the testimony you give shall be the truth, full truth, and nothing but the truth, so help you God.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Good morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Them.
That's Brandon Moats?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year. A little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February of
2020.
2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, you know, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there?
Yeah. Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake, and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah, all the time. It was like a back and forth. Yeah.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
Mr. Cagley, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Are you aware that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them,
Yeah.
were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or you went?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know, from your experience with Sarah Boone and your experience with Jorge Torres, that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you. Hold on.
Yes, sir, of course.
Yeah, class at 1 in the morning. What school is this that has class at 1 in the morning? What kind of classes are there at 1 in the morning? College after dark?
Well, Vincent, I think you had testified.
I don't know, man.
You may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object this to improper impeachment.
Approach.
Okay. Trying to impeach him about something. I'm not sure what, but okay, fine.
No, in the afternoon, because I went to work that morning at.
The lawyers have
For now.
some questioning, and the objection is
7 p.m.
7
I
p.m.
mean, I've heard of night school, but night school at 1 in the morning? That seems like a lot.
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon, because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you.
Okay. Well, some of the people in chat are telling me that my perceptions are wrong on this issue, so fair enough, I guess. Night school is from 1900 hours to 2 in the morning? All right. Noted.
Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was
Co-ed
that
biology at 1
it
in the
was pretty
morning? Cute.
intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes.
This is a slightly strange way to start it's kind of a slow burn way to start the trial, but all right, who you?
Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BRANDON MOATS.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing? Yeah,
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible, usually.
The apartment where you lived, tell us, how would you describe the walls that separated
So,
your units?
yeah, I remember that my bedroom was like the front-facing bedroom, and our walls shared a wall with where their staircase was. So, like, the way the apartments were laid out, we had a one-story apartment, they had a two-story apartment, so they had a staircase running right next to the walls, next to, like, our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin, so if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably. Like, earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that, would that have been on the first floor or the second floor?
We had a first floor apartment.
Okay. So all the units were, or all the bedrooms were on the first floor?
Yeah, like I was saying before, we had a one-story apartment, and then they next door had like a two-story townhouse, so we only had the one floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and then it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally, like, it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, I never saw her after that happened.
No further questions.
Any cross-examination?
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or Jorge Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Okay. Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah
I
sleep?
would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019,
Nice.
when you woke up and witnessed
You tell him. You tell him, baby. You tell him.
Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
Okay. So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling? And
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps to. I was waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
Now, I believe, and I just want to make sure that I heard you, you said that the first arguments, other than the boom, which was 10-something, initially it was around 7 p.m. You heard arguing?
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after because I came home, I made myself lunch, and I took a shower, and then I heard all of their arguing, so it would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth. Or if it was
Let me
just
ask you
one
this,
person
did you
yelling.
hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay, were they both loud?
Yes.
Okay. If I can confirm, Judge.
Yes, sir, of course.
So they're a bunch of drunkards who are fighting in a somewhat toxic relationship, caught in a bad
Sir, I have no
romance,
further questions.
Any redirect?
as Miss
No, Your
Germanotta
Honor.
might
Can this
say.
witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right. All right, sir, you're released subject to recall. Thank you. Can the parties approach?
All right, we have now heard testimony of in kind of theory to visualize storytelling argument in the.
It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time. outside of here, 12 Alpha in the Orange County Courthouse.
Oh,
And I'm going
good.
to give you an
Looking
instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial.
Yeah. no,
Jurors, do not watch local
for us.
news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions
I might
about
even
the
get a little
trial.
quick nap in there.
I want to
be
stress
honest. I'll try
again
to get a little
that
power
just
nap.
as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, please leave your pens and your notepads on each chair. The deputy will collect them. We'll see you at 2 o'clock, and I thank you for your service.
Excellent. All right, guys. I guess that will take us to the break. So I will see you guys back in an hour and a half, which I'm looking forward to a break, and I'm betting you are too. But, a bit of a slow burn start. We learned that they're in a toxic relationship, and we learned that the defense has nothing to work with, which we already knew. So, slow burn start, and that's all there is. So I don't know if there's really anything else to say for the moment. But yeah, I'll just take a break, and I guess I'll see you guys in about an hour and a half. Yeah, I'll see you guys in an hour and a half. See you then. All right, bye-bye.